Shall I start? Okay, so welcome all of you to this presentation. Today, what I'm going to talk about is estate planning solutions. Now, for any family who have got a special need child, uh, estate planning is a very important element, especially when we are answering a question, what after us? So what happens after us? Where would the who will manage things financially, personally? What are the solutions around it, specifically when we are talking with respect to India? So what are the estate planning solutions which are there, and what are these aspects which a family has to take care? Small about us, Special Need Estate Planners Private Limited. That's an organization, company which focused exclusively on advising specially dependent, and we take care all estate and succession planning matters. So, what we are going to understand today is we will understand a bit about key issues. What are there? Understand about will and trust. Why it is so important. We'll understand the roles and responsibilities of various stakeholders. Uh, who are the stakeholders and why we are saying their roles are going to be very important. What are the options for seamless care of a special child post one's lifetime? How the assets can be transferred and how steady income stream can be ensured, which benefit lifelong care of special need child. Let's look at some of the challenges which are faced by families. So, maintaining quality of life for special need child. Every family, every parent wants that the quality of life which they have given to their child, it should be maintained even after them. Equal treatment to siblings. So, if there is a sibling, yes, every parent want that their children should be given equal treatment, though the requirement of special need child are a bit higher than other sibling, but still the wish is always that the care should be equal for both of them. Adequate provision for special need child care after them. uh, their finances should be enough which can provide for lifelong care for the special need child. A proper structure for distribution of inheritance to the child. So how the inheritance will go to the child, the structure should be created around that. So there should be proper structures around it. So these are the challenges which families face, or when they are answering the question, what after us? Now, why estate planning? Why estate planning is so important? Maximizing inheritance designated to heirs. So inheritance which will go to legal heirs, whatever parents leave behind, that inheritance should be maximized. Estate taxes and expenses. So India, we do not have estate taxes yet, but we do not know for the future. So how to address those estate taxes and how to address the expenses which would be incurred during this process. Testamentary instrument, a regular review of those testamentary instruments are required. Sorry. Beneficiary designation and other documents. So who are the beneficiary? There are some tools, estate planning tools or instruments where the beneficiary you have appointed becomes the final legal recipient of that money. And there are some instrument which is where the nominee is not a legal hire. So how these beneficiary designations, the beneficiaries are designated in all these instruments. The guardianship of children, who is going to take up guardianship for the child after the parent? Till parents are there, they are the guardian, but who is going to after them? Distributing asset to the beneficiaries. So if there are two children, so how the asset should be distributed in a proper manner. and manage estate assets. So if you have a large estate, probably how to manage that estate is also important. So these are all why estate planning is so important. And if you look at, then this is what we are trying to answer. This is what we are looking at. Myth about estate planning. So there are certain myths which generally we have experienced or noticed don't have much assets to bequeath. So if you do not have much of assets, why estate planning is not required. I have nomination is placed. Now that's a myth. Nomination is just a custodian. Very small family, so husband, wife, and child. So estate planning is not required. My family is united, so there are no disputes. Will writing is complex and complicated, might upset my loved ones. I still have time, and if I write my will, something will happen to me. So all of these are myths which revolve around when we talk about estate planning. And largely, if you look at, these are all myths. So estate planning is important whether the day you own a single asset, the estate planning becomes important for you. A small family doesn't matter, large family doesn't matter. Families united, we do not know about the future, what's going to come up. And will writing is quite simple. And I still have time, so life is uncertain. So all of these are myths which should be removed, and estate planning should be taken on priority. Sorry. So let me talk about writing a will. Now, estate planning, when we talk about, so there are three major important tools of estate planning: a will, private trust, guardianship, and a letter of intent. These are the four major tools of estate planning for special children families. There can be other documents, they can be other estate plan like a living will or an advance directive, which we talk about. So that can also be an estate planning tool. So they can be other, but these four are the primary estate planning elements. Look at will, trust, legal guardianship, and letter of intent. So I'm going to talk about these four, and then I'm going to talk about the large ecosystem, which is the final estate planning solution, which we foresee. Now, why will is written? Provide specific bequest and direction in your will for the benefit of your child. Such bequest can relate to providing a corpus for the maintenance and medical care. So if you have a special need child and you want your assets should be utilized in a certain manner for the benefit of your child, that can be done only through will. If you do not have will, what happens? If you do not have will, then inheritance laws come into picture in India. Uh, Inheritance law says specifically that if you do not have a will, then the legal heirs, as the law define it, class 1, class 2, all the assets should be distributed equally between them. There is no mention about moving assets to private trust. Now, when you distribute it equally means all the assets distributed equally. Now, that you may not want. That is not your wish. You want your assets to be utilized in a certain manner. So that can happen only through a will. And in a will, it can be as descriptive as you want. You can talk about home care for your child. You can talk about management of your properties. You can talk about management of your estate. You can lay down your wish, how it should be done, how it should be managed. You want to put some conditions, you can put regarding your personal assets. So all these, the way you want to bequeath, you can write it through a will. Appointment of legal guardian after lifetime of your spouse. So you as a parent, you are there, your spouse is there. Now, who's going to be the next legal guardian for your child? That appointment you do when you are writing a will. Setting up of a trust through the will. So you make a provision that at your demise, the trust should be created, and all the assets should move to the trust. The trust is going to take care of your special need child. So we call it a testamentary trust. So you can set up a trust through the will also. Appointment of trustees, nominating successor trustees, criteria, appointment of a protector. So basically, when you are writing a trust, uh, you can appoint people who are going to manage the trust. You can appoint the manner in which they will manage the trust, and you can appoint other persons whom you want to be involved in management of the trust or care of your child, and provision of distribution of income of the trust for the benefit of the child. How the income should be distributed for your child care, monthly basis, lump sum, whatever manner. So when you are creating a testamentary trust, you can define it. So in a will is basically, if you look at, if I have to put it simply, that at your death, how your personal assets should be utilized financially, something about personally also, but financially, how it should be done, who's going to own what, how the asset should be utilized, how the care of your child should be done. You can do it through a will. So you can write a comprehensive will. Sometimes you can write a will and you can attach a letter of wishes also. So you can write a letter of wish and attach to a will, which becomes a document that when the will is finally executed, the letter of wishes is takes care of the way you want the care should be done. And up to the last stage, that how will the corpus be distributed upon the demise of the child. So the corpus will manage your child affair financially, but after the demise of your child, if there is any corpus left, who is going to own that corpus, where it should be distributed, you can write up to that extent. So if you look at will provisions, you can write a very detailed will uh, specifying about your wish, about the way things should be done when you are not there tomorrow. So checklist for creating an effective will. So a small checklist which every parent, when they are creating a will, they should take into consideration. That prepare a list of all your assets. Prepare a list. What are your assets? What are your debts? What are your liabilities? What are your expenses? So prepare a list which will clear out your assets and liabilities. Make your intentions very clear in the will. So when you are writing a detailed will, make your intentions very clear. How do you want to do it? As I said, even a letter of which you attach to a will can make your intentions very clear. Do not keep any ambiguous clause. It should be very clear. If you want to disinherit someone from your estate, the reason should be mentioned very clearly. Why do you want to do it? Avoid making errors. If you wish to disinherit any family member, state the reason clearly why you want to do so. If you leave more for the special need child, clearly state the reason. So there are two children. If you have a special child, you want to leave more assets to him because he requires more money for his care, then you should clearly state the reason why it is being done. Sign on every page of the will, attach a doctor's certificate. It can authenticate of your sound state of mind. Let the executor know about your will. So whomsoever you appoint, people who are going to be involved as an executor or any other role, they should be made aware that this is what your role is, so that it doesn't happen that they come to know in a strange situation they were not aware of, and suddenly they deny that they won't be able to take up this role. Redraft will every 3 years, so 3-4 years just you can review the will. And lastly, take professional help to validate what you have written. So this is a checklist for creating an effective will. Now, what is the estate planning options? So now you have a legacy. What estate planning options you have? That means how you will to decide who is going to manage all the affairs. So there are 3 or 4 options you have. Distribute assets to sibling or family member for special need benefit. So distribute asset to the sibling or any family member you have identified, and he's going to take care, manage all the financial affairs. Gift, bequeath asset to a special child managed by guardian. So you leave everything to directly to the special child, and it will be managed by the legal guardian you appoint. establish a special need trust. So you establish a private family trust. In India, we call it a private family trust. And the trust will take care of your child financially. And lastly, distribute assets to the residential living center for benefit of special need child care. So if your child is going to reside in residential care, both parents' lifetime, then you can give all the assets to the residential care also. Now, these are the four estate planning options every family has. Which one suits your family requirement? Which one you would like to take? You need to choose. But largely, a special need trust can be I would say it's the most beneficial option, considering that you have a separate entity whose role is just to manage the financial care of your child. And nobody owns the asset. Your child only owns the assets. So whatever options you choose, the way you want your asset should be utilized for your child, you should choose and select wisely. Now, estate planning elements. What are the elements which involve when you are doing a complete estate planning for your child? Insurance planning. So, who is going to have insurance? Parents, legal guardian. The benefit would be on special need dependent. So whoever is, so the benefit will go to the special need child. How the insurance planning would happen, how the insurance proceed will go, whether it go directly to your child or whether it go to your trust. So that the planning would be required. Investment strategy. How much is the corpus required? So if we have to answer how much is the money which will be required in total for your special need child care, that needs to be identified. And once that is identified, the funding to the special need care has to happen. So the corpus has to go to the trust or be left to the child if it is left to the legal guardian. But when there is a corpus, then growth, capital security, monthly income, income tax, and trust law, all this will come into consideration. How the corpus will grow, how the capital will be secure, how the monthly income would be generated. All this is part of investment strategy which will be required. When it comes to funding, then whether it is going to be funded today or tomorrow, how the accumulation would happen, how the instant funding would happen. So if something happens to the parents tomorrow, where would this instant funding would come from? Tools to create corpus. So how corpus should be created? Whether you invest into a growth asset or put into fixed deposit, how it is going to grow. Then there is an oversight mechanism. So who is going to look after all these things? Who's going to be the all these things? So who's going where the trustees are going to report? So your in MIS investment report, others, and their protector and guardian who will be involved in overseeing the trust affairs. So these are estate planning elements when you are planning for your child future, especially a scenario when we are talking about what after us. Guardianship. Now, guardianship is a very important aspect. The way law stands is parents are the natural guardian till the child is 18 years. So till the child is minor, parents don't have to seek any guardianship. They are the natural guardian. But the moment uh, child turns 18, then there is no guardian. Once uh, child turns 18, then he or she is an adult. And when she is an adult, then in the law, it is considered that as an adult, you can take all the decisions. So there is no guardian required. But yes, for special needs situation, for support, the legal guardian would be required. So once the child turns 18, then the legal guardianship will has to be obtained by the parents. And in India, the National Trust Act is there, so the guardianship can be obtained through process through national trust. Then there is a testamentary guardianship. That means you appoint a guardian through will. In both situations, now even when the child is minor, the parents are natural guardian. But who is going to the guardian if something happens to the parents? So who's going to take care of the child personally and financially? And even after once the child turns 18, the post parents, who's going to be the next legal guardian? Because for taking decisions on the child behalf, a guardian would be required. A guardian would be required to sign the documents. A guardian would be required to decide for the benefit of the child. Sorry. So who's going to be the guardian? That you appointed through a will. That is called a testamentary guardianship. You appoint in the will that after your parents' lifetime, this is the person who is going to be the next guardian for the child. There is an Indian code, that is Guardianship and Ward Act 1890. It is applicable especially when the ward is in minority. And trust setup. So you appoint a guardian even through trust also, but that is largely more under the laws prevailing for guardianship in India. So these are the ways you appoint guardian. And for any parents, all form of guardianship they will experience. So they will experience the natural guardianship when the child is in minority phase. They will have to seek guardianship once the child turns 18, and they will have to appoint a next guardian through will, that is testamentary guardianship. Identify a person who is going to take up the role of guardianship after the parents' lifetime. But the most important is identifying the next person. Who's going to be the next person? And when you are identifying a guardian for the for after your lifetime, you need to ask certain questions. Do you wish to have a separate guardian for personal and financial affairs? Largely, we do advise that separating the role would be more beneficial. But in what capacity, that we are going to discuss. So do you wish to have a separate guardian for both, or you can have a same guardian for managing both the affairs? Is your identified guardian aware of your child need? The next legal guardian should have some awareness about your child requirement. You can't appoint somebody who do not understand about your child requirement, and he is going to take decisions on your child behalf. Does your identified guardian know what changes they will have to bring in their life? So every guardian who you are going to appoint in the will, who is going to take up the role after your lifetime, will have to make some changes in the will, or some changes in their life, because within the life they are managing, they will also have family. So within that, they will have to make adjustment for managing your child affair. And that's why we ask the first question. Will they be comfortable in managing both the affairs? Because their role will be then much higher. So are they going to ready to make adjustment? Have you considered the identifying guardian as a guardian of the sibling also? So if there is a sibling and during the minority, is he going to be the same guardian? Where will your child live once the guardian takes your role? So are they going to be from the same city or from the other city? If they are in the other city, then there will always be a cost to incur by the guardian. How the guardian will be paid for that cost? How the expenses would be reimbursed? Is your identified guardian a family member, friend, relative, or an institution? If it is, then how does the child respond? Is the guardian known to you? If then whether the child is comfortable or not. So that's a checklist when you are identifying a guardian, which you have to ensure that when you are identifying a next guardian, you do answer these questions, which will make things much easier after your lifetime. Okay. The next in the line is vision. Identifying your vision for your child and explaining it to the world is most important, because that's how you want your child to be taken care of. So let me ask you a question. You leave your child to a neighbor for 2 hours, you can give verbal instruction. You leave it for maybe 48 hours, still you can give verbal instruction. When you appoint a guardian, somebody for the complete lifetime affair, can you give verbal instruction? No. The guardian also has to have knowledge about your child. Not even guardian, all the stakeholders who's going to be involved. For that, you write a letter of intent. That is a vision. Now, what are the components of letter of intent? It uh, it writes about your family, about members, their history, daily routine of your child, habits, clothes and foods, residential, so current residence, where the your chosen option, where he's going to stay, what is not going to work. So you as a parent know that this is not going to work in the residential care. So you describe it in the letter of intent. Healthcare, medications, what worked, what did not work, what therapy should be done. So what should the guardian do if these things come in there? So you write in the letter of intent. Social activities about your child, sports, dance, vacations, education, the special schools, special classes, religious places of interest, likes and dislikes, and final arrangement. So if you look at component of letter of intent, you are writing the complete lifetime affair of child. Somebody who wants to know about your child can read the letter of intent, can understand. And it will also contain details of professionals. So for guardian, if they want to consult a regular doctor, where would they search for? They will look at the letter of intent. So that's why this is such an important document. In fact, the moment you start estate planning, this is the first document any family should prepare, so that uh, you have a document which contains about your child life, and the next person or stakeholders who are going to be involved, they can refer it to it and understand about your child affairs. Let's come to the private trust, which is the other important element. Now, the estate planning solutions I have spoken about, that these are the 4 estate planning options, that either you give it to directly to the child, let it be managed by guardian, you give it to any family member, you give it to the residential care, or you form a private trust. A private trust comes near to a probable estate planning solution, where you leave the assets to an entity which is created only for the benefit of your child. Nobody owns these assets. These assets are only for the benefit of your child, and that's where the trust structure comes in. What are the benefits of private family trust? There is no restriction on settlers or those who can create the trust, no standard terms of the trust. A trust is a separate entity. It does not go through a probate. So when you are writing a will, and if you leave everything to the will, now a will can go for a probate, and a probate process can be lengthy. So till the probate process is not completed, the will is not executed. So what happens to your child care during that period? A trust is separate. It does not go through that process. Whoever creates the trust can appoint the initial trustee. So you as a parent can appoint the initial trustees, or you can also be an initial trustee in the trust. A trust works only for the beneficiary, and most importantly, it avoids any conflict among family members. Now we have 3 types of trust: revocable, irrevocable, and testamentary. Testamentary is basically you create a trust through a will. So it is not created today, it is created at the death when the will is executed. So all trust rules are written in the will. But if you create a living will trust or a trust today, you can create a revocable or irrevocable. A revocable trust is more when you would like to amend it, you want time to understand it so that you can change it later on. So that's where you create a revocable trust. So you can revoke it, you can dissolve it, you can change it, you can amend it anytime. The asset ownership doesn't change in that. It is rest with the settler only, and convert to irrevocable on settler's death. Irrevocable is contrary to this, that it cannot be revoked, and assets become property of the trust when the assets are transferred. So both are beneficial depending on when you are starting, how do you want to look at management of the trust. You can create a revocable or an irrevocable trust, or if you do not want to create a living trust, you want to leave it to the will, you create a testamentary trust. So the trust would be created when the will gets executed. So these are the type of a trust you have the role of a trustee. The trustee is the person who's going to manage all the trust affairs. Settler is one who create the trust. Trustee is the person or are the person who's going to manage the trust affairs. Trustee would be the people who's going to be uh, who play the main role in managing all the trust affairs. So what is the role of a trustee? Is supposed to make only profitable decisions for the entity. So their role is only to make decisions regarding the benefit of the special needs child or the beneficiary. It's a legal relationship between the trustee and the party. So once any individual or organization become a trustee, they are taking up a legal responsibility to ensure that they are managing the trust affairs and taking the interest of the beneficiary of the priority. And the trustee is not to suppose to make any profit for themselves, but using the resources of the trust. So they are only supposed to manage the trust within the trust deed setup, within the provision which has been done, and only look after for the benefit of the beneficiary. That is your special needs child. Again, you can be the initial trustees, your parents can be the initial trustees, but you have to identify trustees. Who are going to be trustees after them? You might have identified somebody, but always look at certain aspects when you are identifying a trustee. Some qualities should be there in the next person who's going to be trustee after the parents. So he should know how to manage investment account, taxation matters, not knowledgeable, but he should be able to know that what kind of a professional should be hired for this. He should be able to manage relationship. The beneficiary is a special need child. When there is a special need child, the trustees has to think from that perspective. So they should be able to keep a good relationship with other professionals, doctors, medical professionals, residential care, and all other professionals which would be involved, and avoid conflict. So their top priority is the beneficiary. So as far as possible, the person trustee whom you appoint should be know how to avoid conflict. Individual corporate, you can appoint anybody. Individual family members can be appointed, or friends can be appointed, relatives can be appointed, or a corporate and organization like ours. So they can also come in as a corporate trustee. So whenever you are identifying trustees look from this perspective, look from that angle and seek the consent of the trustee so that he knows very well that what role he has to play. Special need trust, this I have spoken about largely. So the way it is that parents create a family private trust, revocable or irrevocable, management and beneficiaries. So parent become initial trustees. Parents identify and appoint future trustees. Parent can also be the beneficiary. So it's not about the only child. Parents, their old age will also be an aspect which every family, every parent has to think about. Now, same trust which can look after the child can look after the parents also. Managing the corpus, investment, growth, tax efficiency, sustainability, fund cost of child care. So the trust can fund quarterly, half yearly, annually, any lump sum requirement comes in. So whatever manner the funding for the child care has to happen, the trust can do it. It can provide security to assets. So once the trust becomes irrevocable, then assets become the trust property. Monitoring of a trust. So appoint trustees. Now you can appoint mix of trustees, family members, parents, professional trustees can come in. So when there is a mix of trustees from different areas and not knowing each other, probably can be a good framework for a trust to be managed efficiently. And lastly, we say it's a most viable structure. You can set up layer of securities to ensure flow of funds for expenses, and the income distribution can be as flexible as you want. So it's a private family trust. Yours, you can create it as per your own requirement. The way you want it for the benefit of your special needs child, you can create this trust. Now, who are the stakeholders? So there are guardian, individuals can be there. NGOs, if registered with National Trust, can take up the guardianship. One of the trustees can also be the guardian. Then there are trustees who are going to manage the financial affairs. There is support, people in support, family member, friends, parents, community. Then there are service providers, residential living, medical professionals. These are all stakeholders. And when we talk about stakeholders, which means they are all of them would be involved with your child affair. Now, we have estate planning tools. You have created estate planning tools or estate planning, these legal documents. They are functioning. But what can be the biggest problem? The biggest problem is that the sync of these stakeholders with each other. So if the guardian is not aware about what's happening with the child care financially, then taking up consulting even for any decision uh, might take up more time. Similarly, so if all of the stakeholders are not in sync with each other, then making decision on the child behalf can be inefficient. And that's why we say that an ecosystem has to be created which ensures that all the stakeholders are in sync with each other. And that's where an ecosystem comes in. So now, what is an ecosystem? An ecosystem is a system you create wherein you ensure uh, you have a private trust. A private trust becomes a major entity who's going to take care all the financially. Then there are stakeholders, supports, people, service providers, residential living centers. In this ecosystem, you set up a monitoring system. The trust creates, the trustees become the major stakeholder. They set up contracts with all the service providers and all other stakeholders. And a monitoring system is created regularly, efficiently, a periodic monitoring system which ensures that it is accessible to everybody and it's being monitored by the main family member and everybody has an access to it. The medical professionals upload the regular report, the residential care uploads the regular report, the guardian can see it, the trustees who have set up contracts with the service providers. So they ensure that the regular periodic monitoring is happening and the reports are being submitted. And trustees submit the reports finally to the person or the people who are overseeing the trust mechanism. So this ecosystem, the benefit of this ecosystem is that a review system like this, a periodic system like this can ensure that all the stakeholders, they are knowing about the child care, what's happening, and tomorrow if any decision has to be taken with respect to the child, the decision is more efficient. So this ecosystem is much more important to bring all the stakeholders under one roof and under an ecosystem where everybody knows that the child care, where it is, what's happening, how the decisions are being taken. Okay, just to end up with, I'll take up a small case study. So Vicky, 27 years old, is a special need adult. Gaurav wishes to estimate corpus required for lifetime care. Let's assume life expectancy of Vicky is 70 years. Average inflation of 7% is assumed for increase in expenses year on year and a growth of 8% of the corpus. Now the trust has to be funded with, but it's not only the fund for the child. There would always be certain amount of expenses with the trust will has to incur. So this is an expense chart which we create. So suppose Vicky yearly expenses or monthly expenses is 58,000, which Gaurav has estimated. Based on the estimation of the lifetime, what Vicky require is a corpus of 2.4 CR. That means if Gaurav has this corpus today, he can be rest assured that Vicky expenses would be met for the next 43 years. That is till till the lifetime of the child. But as I said, they can be recurring expenses for the trust. So trust administration, let's say example, trust administration 50,000, income tax yearly 20,000, other expenses might be 20,000. There might be a yearly cost for trust management 90,000. So total yearly expenses to be planned is now 7.86, 7,86,000. So actual corpus which the trust has to be funded is 2.79 CR. So that's the difference is there. All these estimation are important. All these estimation are important because creating trust is one aspect. It's the starting aspect. If the trust doesn't have fund, the child care won't happen. If the will is not written, the fund won't come to the trust after the parent's lifetime. So what will trust do? Trust won't do anything. So everything would be done whoever is having those assets. So this is much more important. Ecosystem for Varun, 48, 2 years old, is a special need adult. Varun father Ravi, 75 years old, and wish to plan for Varun care considering his old age. Varun mother died 10 years ago. An immediate family member available is younger brother who is NRI. So his brother's son is also NRI, but Ravi wished to involve him to oversee Varun care. So here's the situation. Varun is a special need adult. Varun father is 75 years old. He has a younger brother who is an NRI. He wants to involve his brother's son, but for Varun care. And Ravi wishes to have Varun stay in their existing residential home. So Varun will stay in the residential home, but the trust needs to be created, and people he has identified who are going to be involved. So how do you create this ecosystem? One second. So Varun Family Trust is created. Ravi as settler and guardian. Ravi is the guardian today. So he appoint initial and future trustees. So Ravi identified one more trustee and also appoint future trustees. So there are professional trustees who are appointed, a company, a corporate or professional trustees. So they manage his day-to-day affairs. They set up contract with service providers for institution, medical professional, other professionals for regular review and monitoring. And the trust set up the periodic review monitoring system with all the stakeholders. Now the NRI's son, his brother son, who is an NRI, he is not involved directly as a trustee, but he is involved as a protector. And he is going to oversee all the affairs once he, after Ravi lifetime. And the trust funding happens through investment, life insurance, gifting. The trust who has set up this review system is reporting to the protector with all the reports, the regular periodic review reports. So trust has become the main entity. All the service provider, residential care, medical professional connected to them. The contracts have been set up where all these stakeholders have to give a periodic report to trust. And the trust is sharing those reports with the protector who is going to oversee all the affairs. This is how you set up this ecosystem. And this is what estate planning solution we are talking about. So you can create legal documents, fine. You can create, you can fund them, but unless and until an ecosystem is created, it is very difficult to ensure that everything will run smoothly as you want it. The myth and concern about estate planning I have spoken to you about. This is again certain myths. My other children will take care of this child after me. We do not know. We do not know where the child would stay, and you, as a parent, you also do not want to lay a stress on the sibling for managing the affairs where he might have his own dreams and want to do something. So all these are their myth which needs to be resolved, which needs to be set aside, and an estate planning, look for an estate planning solution for your child, which where all these documents are not only created, but lastly, the ecosystem has to be built. Without this ecosystem, it will always be difficult. Sorry. Okay, that's all about estate planning solutions. happy to take up any question and answer if they are. Okay, thank you everybody. This was about estate planning solutions of how special need children families look forward to, and I'm sure what I have spoken about today uh, is a way forward, and happy to we'll be again we'll come up with some other important elements of estate planning. Thank you and see you.